All right, Judge. I think this is I'm the last one, and I do appreciate your indulgence over the past couple of days. These cases are always interesting because it's always, I feel like the movie 300. I don't know if you've ever seen it, but there's 300 men against the entire Persian army. I'm 300 against the entire Persian army, but that's okay. I know that the court will look at the law and not look at the volume of voices on each side of the V in reaching the right decision in this case. I will start with a couple things, which is it appears at least some of the counsel are admitting to the three movers, and it appears that we've got 11 disenfranchised that admitted. That puts us at 14. So hopefully those are taken off the table. I'll let the record reflect itself on those issues. The next issue is the moving with dispatch Mr. Sparks brought up. If that was an argument or motion, it's entirely untimely. That motion should have been filed at the beginning of this case. It also shouldn't have been made at closing argument in a case after a trial had been completed and we've had over 2.5 days of evidence. Obviously, we reserve the right to respond to that motion if and when it's filed, but I do not think it deserves too much of the court's attention today. The next thing that I'll get to is the Meade case, and I know we've talked about it ad nauseum. This is, and I understand the counties do not have a lot of directions to go and do not have a lot of defenses in this case. And I think because of that, there has been some reading of the case that directly defies the language of the case. The one thing to me that's particularly troubling, and I know multiple of the counsel has suggested that, in fact, the record will reflect directly said that the voter made the mistake. These voters made no mistake. These voters were misassigned. The Secretary of State's email, first, Ms. Brooks was trained on how to use Esri. She testified she did not use Esri. Now, she was sick. That's fine. She didn't use it. If she would have used it, these issues probably would have been addressed. Because if she would have used it, 95 misassignments would have been identified. And hopefully she would have corrected them well before the election. That did not happen. That's in the record. She testified to that. If the McDuffie County is now blaming that on the voter, that's a pretty big problem in my opinion. Taking it further, we get to and through the election. To and through the election, every certified voter document has affirmed time and time again these people got the wrong combo code or the wrong ballot. The defense has presented nothing. And this record is fantastic. And the Secretary of State is going to really enjoy reading this record. There is nothing in the record that suggests on or before November 5th any of these documents were inaccurate. There is no document that says they are inaccurate. There is no testimony that says they are inaccurate. In fact, Ms. Brooks never even accessed it on or after December 3rd, 2024. And to cast doubt, to talk about Mr. Sparks saying casting doubt on results of election is questionable, to cast doubt on every Secretary of State file statewide suggesting voter certificates could be inaccurate, that is reckless. And it's wrong. We do, in the case like this, we have the burden and we met the burden. The defense has the burden to then disprove or rebut what we've done. That has not happened. The only thing that has been offered at all is Ms. Brooks coming up talking about Jarvis reports, which were after the fact, and in fact, months after the fact. The best evidence for the ballot that these individuals received, Judge, is these voter certificates. That's the best evidence. There are many individuals that don't remember what they had for lunch yesterday, much less what ballot they voted on back on November 5th, 2024. It is very difficult to imagine that these people would remember which House district they had on their ballot. But if these guys wanted to call them on the stand and try to disprove the best evidence, which is the voter certificates, they could have did so. They did not. They have offered nothing. No testimony to refute these people got the wrong ballots on or before November 5th. No document to show they got the wrong ballots on or before November 5th. Ms. Brooks has admitted these folks were misassigned. They were given the wrong district. Warren County has admitted the same. Secretary of State told them, hey, you need to look at this. There is nothing done on or before that point. So I take issue with suggestion that when you have counties that admitted mistakes, when you have counties that have stipulated to mistakes, to then suggest that that is on the voter, that is not okay. Period. I understand they're fighting hard for this. They do not want a new election, clearly. That is not what this case is about. And let's read what Meade says, because Meade is effectively spot on this issue. This is on page 101. The electors who received the irregular ballots did not cast illegal votes. As qualified electors, they cast legal votes on irregular ballot. However, because the irregularity relates to the list of qualified candidates, that is exactly what this is. This case is, who are the right candidates that should be on the ballot? Should they have gotten House District 125 or should they have got House District 128? Who are the qualified candidates? Because the irregularity relates to the list of qualified candidates from whom the electors were selecting, the ballots were prohibited by law. These are illegal ballots. It's not illegal votes. None of these 24 people did anything wrong. They went to vote where they were assigned. They showed up. They gave their driver's license. They put in the voter card. They cast their ballot and they left. But they got a ballot that had the wrong qualified candidates on the ballot. And just like Meade says, because the irregularity relates to the list of qualified candidates from whom the electors were selecting, the ballots were prohibited by law. These ballots were prohibited by law. Right here. They're illegal ballots and were therefore inherently illegal. This is straight from the case, Judge. And their distribution to the voters was unauthorized. These should not have been given to the voters. If you don't live in House District 128, you should not have received a ballot for House District 128. And if the ballots being voted as furnished, they voted the ballots as they were furnished and under a misapprehension of the validity. The voters assume they are valid. Why wouldn't you? Do you assume your ballot is valid when you vote? I do. We all do. They based upon a misapprehension of their validity and did not operate to validate them. They should unquestionably be discarded. You cannot get more spot on than that. Representations that is not what this case is about are desperate. They're desperate representations. Taking it even further, the 2008 case, which the Georgia Supreme Court expressly says, what is the holding? The holding, where alleged irregularity focuses on the ballot themselves, not the manner in which they were cast. The number of votes necessary to cast down on the result of the election is ascertained by the margin of victory. This is about the ballots themselves. It's not about how they are cast. It's not about how the people, whether they were engaged in voter fraud and tried to vote for someone else, or they didn't reside at an address they were registered at. The McIntosh case here, I'm reading from it. He failed to show that the votes deemed illegally cast. That doesn't apply to this case. We are not saying that these voters illegally cast a vote. What we are saying is exactly what the Meade case says. Because the irregularity relates to the list of qualified candidates, that's exactly what this is. You can't get more spot on. The ballots were prohibited by law, a legal ballot, and therefore inherently illegal. And their distribution to the voters was unauthorized. The voters should not have gotten this ballot. They didn't live in House District 28. That's been stipulated. They were given this ballot. That should not have happened. And if the ballots being voted as furnished, they were under misapprehension of their validity. Voters assumed they are valid. They were not valid. That did not operate to validate them, and they must be discarded. You cannot have a more clear-cut, straightforward decision before the court. I understand the counties and respondent don't have a lot of directions to go. But claiming, oh, you had to call these people in, you had to do this, you had to do that, they could have done it. If they wanted to dispute these individuals got the wrong ballot, they can't sit on their hands and present two witnesses, one expert that virtually said nothing, and Ms. Phyllis that just said what documents said. You can't have two witnesses. You have to present something to invalidate a voter certificate which says clearly issued moments before they got ballot 132. It has to be more than speculation about Jarvis on or after December 5th, 2024, which is undisputed in the record. Any suggestion that this case is about mere conjecture and speculation defies the overwhelming record in this case. This is not a speculation case, Judge. This is a case where it has been stipulated these people live in the wrong district. This is a case where the records show they were assigned a certain combination code and received a ballot 132 to that, which they should not have been furnished. It relates because the irregularity, again, I've got to drive this home because respondents have made such an unbelievable issue because it is their only way. But they're misrepresenting the case. The case cannot be more clear on this issue. Because the irregularity relates to the list of qualified candidates. Here it is, right here. Qualified candidates. They should not have gotten that. The ballots were prohibited by law. They are illegal. They are still distributed. They shouldn't have been. They must be discarded point blank into discussion. There's been suggestion that we have not proven that the procedure was not properly done. That is unbelievable. Based upon the fact that Ms. Phyllis did not do Ezra prior to the election, she admitted it. She was sick, but she didn't do it. She should have. That would have identified these issues, and you hopefully correct it. Didn't happen. The fact that these ballots, that these individuals, which they've stipulated were assigned to districts they didn't live in, the voter certificates here indicate they got a ballot that Meade says was illegal. That's a violation of the election code. This is not pontificating about possible issues that may come up. This is about as clear-cut a case with cold, hard documents. And to show you how cold hard it is, you have suggestion that the entire voter database statewide with the Secretary of State could be inaccurate, which is absolutely ludicrous. And there is nothing in the record to suggest anything about any issue that the Secretary of State, the voter database, the absentee ballot file, the CAS report, that any of that is inaccurate. It is 100% accurate. There was a change done in December to the street code, the street segment. That doesn't reflect on an individual voter file, and that is exactly what happened in this case. So, to conclude, Judge, we have proven 27, which are in essence not disputed about the wrong ballot. There are 24, which we have been admitted they are assigned to the wrong district. Those are, in my opinion, proven conclusively by the voter certificates that were issued moments before they voted. You've got Mr. Shelton, who lives in Glasscock. The address pays property taxes in Glasscock. There is nothing other than mere speculation and conjecture. You must offer more.
Your Honor, I'm going to have to object. That mischaracterizes the record and the testimony. Mr. Shelton did not pay. It was not named on the.
I said the property pays property taxes, and I'm giving closing statement. The record reflects itself. The address which Mr. Shelton is registered to vote at, and everything in the record suggests he lives at, pays property taxes in Glasscock. He wasn't allowed to vote in Glasscock. And then you've got the three movers, which appears are not in dispute. Then you have the three in Washington, which Mr. Davis established are in Washington, but they weren't allowed to vote. This is in no way, shape, or form, Judge, a mere speculation case. This is a case where you had systemic issues from start to finish. You had a failure to use Jarvis, which the record and the emails show Ms. Brooks was trained on. You have her not using Jarvis. You have 93 issues which could have been corrected. They weren't done. You have the people getting the wrong ballots. You have all the voter data saying they got the wrong ballots. Even by them, they're saying, oh, there's a conflict in the evidence, which says we don't know who got one ballot, whatever. It doesn't matter how you shape it, Judge. If you go under the systemic irregularities analysis, which is Georgia Supreme Court's recognized, the result of election may be voided where systemic irregularities in the process of the election are sufficiently egregious to cast in doubt the result. Supreme Courts went on to say, we agree with the trial court that these irregularities, which affect over 163 ballots, are sufficient to cast in doubt the result of the election. Therefore, the election must be voided. So in the end, Judge, the evidence is clear. The record is robust. You have people assigned to the wrong place. You have people getting the wrong and illegal ballots. And you have law that makes very clear that if you have a ballot giving improper information as to qualified candidates, that is a legal ballot, and that exceeds the margin of victory. You also have the opportunity and absolute, I would argue, obligation under these facts to overturn the election under the systemic irregularities prong, which has been done more than once, not at the appellate level, but it has been done at the trial court level. We are happy to submit a trial court brief, Judge, or post-hearing brief, and if other parties want to do so, we would respectfully request that be done promptly, probably by next Wednesday. But we very much appreciate the court's time and attention. I think we've done this case very expeditiously given the volume of the record. And that will conclude my remarks unless the court has any questions.